Okay, in this presentation, we're going to talk about some of the finer points of drafting petitions and to some degree motions. So in our materials, we have in a discussion of detailed drafting of petitions, all right, and motions. We're not going to get into which line goes where, but of course you've got your style. Hopefully you can cut and paste that from a prior document or create the appropriate pleading. But when we talk about drafting petitions, there's a few important common themes we've got to deal with. First, if you're new to the firm, ask somebody like me or Sharon or Gil, somebody there in Stanford who's been around for a while, have we drafted a similar petition before? Okay. Now, of course, everyone's different, but in petitions, there are some elements that we have to deal with. First, your introductory paragraph, you define plaintiff and defendant as either mother and father or husband and wife. Okay. Obviously, if it's parenting related, it would be mother and father. Now, this video is more about the art side, and this is the fun side of being a lawyer. We're going to talk about some of the mechanics, but we're also going to be talking about themes and theories. All right. You have in your materials discussion of the difference between themes and theories and how they relate to what we do for a living in family law. And the development of those themes and theories will make the difference of whether our client wins in court or loses, and hence the art. Okay. Now, a theory could be that our client should be primary residential parent because they are the education parent. And you've heard me talk about that many, many times before. Usually, but not always, one parent is more actively involved with education. Now, certainly there's some mothers and fathers that divide up along their strengths. Like I typically worked with my kids on math, but not so much on the social studies or English side. Generally, my wife did that. She was much smarter on that. But, and I tried to make all the parent-teacher conferences, but I didn't make them all. I went when I could, and if I was out of town, I'd miss it. All right. So there's a number of facts and factors that go into which parent is stronger in education than the other parent. And that could be a theme and or a theory. The theme is my client's the education parent, but try to catch all the key facts that relate to who is the education parent. So communicating with teachers, making sure the homework assignments are understood, completed, parent-teacher conferences, homework assignments, projects. There's usually going to be one that's going to be working harder than the other. Now, that doesn't mean you're going to win, but it's certainly a big factor to me if I were a judge. And some judges are going to consider that without telling you, okay? Because a lot of times I'm convinced that our judges, and I say all family law judges, don't always articulate the key factors because determining who the education parent is often about evidence, okay? So how do you prove that one parent never went to parent-teacher conferences? Well, you can have testimony of the other parent, because I was there and I personally did not personally observe the other parent at these meetings. Sometimes it may require involving the teacher, which is no one likes to do, but sometimes we have to do. All right, so your themes and theories are going to set up the format of your petition, okay? So what I like to do, and this is not as far as the mechanics, this is not rocket science. You have your intro, who you are, what you're asking for. Wherefore premises, wherefore premises considered, no, that's at the end. For grounds. And then, if that's section 1, I wouldn't label that as a section, but your next section, or section 1, is facts. Or can be, because remember, this is art, not science. So you want to hit what we're asking for, and you want to order your facts in order of importance and power. All right? You don't want to bury that a child was physically dominated by a parent in paragraph 24. You want to lead with it. Whatever's the most important fact that helps out with your theme and theory, lead with it. All right? Then, if you have multiple requests for relief, right? Say, drafting a petition to modify parenting time. Right? Then you go in with section 2, cause of action, maybe introduce it in terms of in support of the request to modify parenting time, mother states, and then go into the key facts regarding that specific request for relief. Now, what we do often is incorporate all prior statements within each section. And that sentence would read something to the effect of, in support of the request to modify parenting time, party, parent. Oh, and I like when we're dealing with children and we're talking about parents, I like to use parents, not parties. Our client, the parent, mother or father, incorporates by reference facts listed above in section 1, paragraphs 1 through 28, whatever they are. And then we could start with paragraph number 29. Now, as we draft facts and arguments, never forget 2 things. One, we want direct, clear, concise statements. If you got a semicolon anywhere in there, the sentence is probably too long. One of the great ways, if we're talking about the education parent, you can say, mother failed to attend any parent-teacher conferences for either of the 2 children, period. Okay? That's direct, clear, concise. You can say, mother almost never attended. Cover our base that maybe our client's wrong about 1 or 2. You could say, mother rarely attended parent-teacher conferences or meetings for either of the 2 children. All right? So those would be some examples of clear, concise, direct statements, generally going to be in past tense, and we never, ever, strike that, we rarely use passive tense, right? Passive tense or subjunctive tense, past perfect. Well, we could do past perfect. But in general, nothing passive. So anytime you say was, supposed to, or anything in the passive tense, take it out. It's not great writing. All right. Now, And again, advocacy comes down to hitting both the mechanics on one side and merging it with your advocacy. Mechanics, advocacy. So for custody, we have to make sure that we plead a material, strike that, change of circumstance which materially impacts the child's well-being. Now, as a family lawyer, having practiced for 25 years, I can spout that off, even though I made a mistake earlier. And so there are general standards that must be met in every pleading. It's not that exciting. If you have a question, ask. Right? Now, what makes Tennessee family law and all family law a little weird when it comes to pleading the mechanics? Well, probably within 20 minutes, I could go find 5 different custody cases in which the standard for modification of parenting time is stated just a little bit differently. Okay? And I'm sure there's a clear, concise, direct statement somewhere within Tennessee family law as far as the difference between the non-primary residential parent, or how we call them in child support, the alternate residential parent, wants to go from 100 nights to 150 nights versus going from 100 nights to being the primary residential parent and having 183 or more nights. All right. Is there a difference in standard? Yeah. Is it articulated in a clear, concise way by the Court of Appeals what the net difference is? Kinda. All right. And it's more of a distinction based on application than anything else. All right. Now, which brings us to the mechanics. As we worry about the mechanics of a petition, we should consider looking at appellate cases dealing with that issue. It's not that complicated. You can go to Richard's Tennessee Family Law. You can go to my blog. We have custody modification, which includes parenting time modification and or who's going to be primary residential parent. Okay. And why do I use custody in my blog when we're not supposed to use the word custody in Tennessee? The answer is because everybody knows what that is. All right? It's just simpler. Doesn't make it necessarily wrong. All right. So, as we go through the mechanics and whatever standard we have to prove. For example, we just came up with a matter in the office where we're looking to modify child support. Okay. What do you have to do to modify child support? 15% change. Not that big of a deal. But how do you know it's going to be a 15% change until you review both parties' tax returns and run the numbers? You don't. But we still need to plead that there is, and we could put in there upon information and belief, or we could plead in the alternative. If there is a 15% change in child support, we ask the court to modify. Okay? And just be straightforward with the facts as it relates to the child support modification. All right. So, themes and theories, advocacy. What's the most powerful thing? Often, unfortunately, the most powerful thing when we're drafting a petition is a parenting mistake by the opposing party. Okay? And that's where we have to get into, do we list our evidence? Do we show the other side what cards we're holding? All right? And before we draft these petitions, I highly recommend that we have all the evidence from our client in our possession. Now, typical forms of evidence relating to custody, real simple. All the text messages, email messages, social media postings, photos, as well as grades. Grades are a big one. If there's a physical problem or learning disability, we need documentation regarding that. If there's an IEP, we need it. All right? And getting all of those documents from our client and reading them takes time, but it's time well spent. Now, certainly we want to ask our client, what do you think is the most important that we damn must know? No question. And it's very frustrating if you've already started the draft of your petition, show it to the client, and they say, well, you didn't put in X. Well, you were supposed to give me X off your phone 2 weeks ago. All right? Now, that stinks, but it happens, and it happens all the time. Right? So that's why it's so important that we get all of our ducks in a row. But in family law, you don't wait to get your ducks in a row to start drafting. Okay? Especially, just take your marital balance sheet. Marital balance sheet is a daunting task if it's done well, even on a relatively small estate. All right? But getting it done accurately and thoroughly may require multiple sessions. So get started. Same thing with the petition. A lawyer could ask a paralegal or a law clerk or a legal assistant to blank up the petition and get it started. Put the parties' names, put in the requested relief. All right. Start building a map of what you want to argue. Don't forget the custody factors. If it's a property division matter, don't forget we need to argue the property division factors. If it's a petition relating to modifying alimony, we better be considering all the statutory factors for alimony. Don't forget about the basics, the mechanics. And it's my opinion, right, that the faster you can get your framework in order, the better your petition is going to be, because you don't want to be drafting a petition in one setting, especially if it's a complex petition. Get it started, get the framework together, and then start adding your themes and theories and your advocacy over time. And at the end, don't short or give less thought to what's the requested relief. Wherefore, premises considered, wife asked the court to order as follows, number 1, 2, 3, 4, 5. Be detailed, be specific. One of the hardest things, strike that. What most judges will say is their number one tip to lawyers that appear in front of them is tell me what you want. Okay? So we're going to ask for a requested relief at the beginning of the petition, and the requested relief at the beginning of a complex petition may read, request the court order as follows, A, B, C, D, E, F, G, as far as requested relief at the beginning, and we may have that exact same language at the end. So we tell the court what we want, we tell the court what we want at the end. Now, as far as the sentences in between and the headings, when you draft a heading, be creative. Okay? And keep it short. I don't want to see 3, 4 sentences or one long sentence in your headings. Father should be primary residential parent because he's the education parent. That can be section 1. Then lead with your strongest facts. Father should be primary, or mother should be primary residential parent because of father's extreme anger. All right. Well, do we have video? Do we have text messages? Do we have this? Oh, a quick aside about text messages, we have to read the entirety of them. A couple of things. One, of course, we can't, it's unethical for us to have to direct our client to delete any electronic evidence, ever, whether the mandatory injunction exists or not. Then second, if our client has a smoking gun text message from the other side where the other parent makes an admission that's very serious. Well, what if our client has told the other parent 48 times in that series of text messages, FY, FY? And I'm not just saying are the abbreviations, okay? Or something worse. You know, your son knows you're a POS. That's bad. Okay, hopefully our clients aren't writing anything like that, but sometimes they might have. Okay. Now, even though the statement may in fact be true, all right, that's not something we need to really consider whether we want to go forward with that petition. So again, or at least that section of evidence, we may not want text messages to come out. That's a decision for the lead counsel and myself and the client to work through. And then hopefully we educate them not to use such language in text message. All right, so the advocacy starts with your headings. You put in there short declarative headings that state your theme and theory. There are no rules, but I just don't want the heading, father should be PRP. That doesn't do anything. Father should be PRP because he's the education parent. Does that make sense? So whatever that is, put it in there. And generally the lead theme and theory is going to be our strongest, have the best evidence, and be the most shocking to try to get our judge's interest. Do we care whether the judge is likely to read the petition? Yes, of course we care, regardless of whether they're going to read it. It's kind of a trick answer instead of a trick question. All right, meaning we are going to assume that all and every time that the judge is going to read our petition. And if the judge doesn't read it, maybe the appellate court has to. Right? And the judge may not read it for our first setting, third setting, fourth setting, but may be waiting for a hearing or trial on the merits. That all being said, we want to have a great work product. And many times we may want to incorporate references to law, especially if we're talking about a standard. Let's say we're writing in some sort of petition or motion as part of a divorce action and the marriage lasted for 4 years. Parts of our theme and theory of the overall case may be this is a short-term marriage. Try to, in the court's direction from applicable case law, is put the parties back in the position they were at the date of the marriage. Now, regardless of the fact that that's a terribly difficult assignment to do because that requires a judge to rewind the clock, that law may in fact be very advantageous to our client in consideration of the overall division. And if that's the case, we want to make sure that that statement appears in every motion, every pleading we can, with citations to applicable Tennessee case law. Okay? That's just an example of things we may put in the petition over and over and over again to try to make a point. And I do believe in repetition to make a point. And that may be twice within a petition. It could be whether we put it in every petition or motion pending the trial, okay, including our pretrial memoranda of law. Okay. So repetition is fine. Citing case law is fine. Nothing wrong with it. And if it is a complicated family law issue, we may need to put in law. into the motion of the petition itself, rather than have a separate memorandum of law in support of petition to modify PPP. Okay. It just depends. That's part of the art. Right. Now, as of a few years ago, the appellate court said all memorandum of law needs to be filed so that it's in the record, which is good. So we need to remember to file it. And we had filing deadlines for separate memorandum of law. Any questions? All right. Hearing none, we're done with this presentation.